Fourth line. This raises a question as to what are taxes on mineral rights. Obviously, taxes on mineral rights must be different from taxes on goods produced. If taxes on mineral rights also include taxes on minerals produced, there would be no difference between taxes on mineral rights and duties of excise under 84. A comparison of list 1 and 2 shows that the same tax is not put in both the lists. And whereas 50 is a unique entry, it uses the word tax on mineral rights. They don't use the word mineral development, they don't pick up the word for anywhere else. Therefore, taxes on mineral rights must be different from duties of excise, which are taxes on minerals produced. The difference can be understood. I'll skip those lines with your permission. Come 4 lines below. There should therefore be no difficulty in holding that taxes on mineral rights are taxes on the right to extract minerals and not taxes on the minerals actually extracted. This is actually my proposition 4. It's coming later, but the judgment is the same. Thus, tax on mineral rights will be confined, for example, to taxes on leases of mineral rights and a premium of royalty. Taxes on such premium and royalty would be taxes on mineral rights, while taxes on the minerals actually extracted would be duties of excise. And then the last 4 lines underlined, not boldface, last 4 lines, same page. Therefore, the present cess is not a tax on mineral rights. It is a tax on the minerals actually produced and can be no different in pith and substitute from a tax produced. Now, Malas, Saurashtra, I know, has been cited against us, B19. I'll skip that because it is approved by Kesoram. Malas, I'm skipping that. That is cited in B19. Come to B20. Malas, what is the reason in Saurashtra? With the deepest humility, the reason is, if you don't want to have this tax, don't go mining. Well, is that an excuse? That's the reason given. Now read my para B20. Every indirect tax, fellows, in that sense is optional. If I don't go and buy a good, I won't have to pay the tax. So that means I should not buy the good. However, the underlying logic of this reasoning, well, this reasoning is the Saurashtra reasoning, Gujarat High Court. It is respectfully submitted, and that's adopted by Kesoram. That's the problem. Gujarat by itself would not have been a problem. It's adopted by Kesoram. It is respectfully submitted, patently erroneous, in as much as the choice of whether or not to undertake mining operations by obtaining a mining lease cannot possibly take away the character of royalty as a tax, for the reason that this choice is available with respect to all indirect taxes. One may or may not buy goods or may or may not avail services. That cannot possibly make the indirect tax that would otherwise follow something other than a tax. Now, Malats, who are the people operating this system? See the next paragraph. From time immemorial, apart from India Cements, apart from 9 judges, this is the Indian Bureau of Mines, which is the mother organization for all this. Royalty in the strict sense and common parlance may not be a tax. It can be viewed as a kind of tax, which is why 366/28. Linked either directly or indirectly to the intrinsic economic value of a mineral realized through sale by the lessee. Royalty of mines cannot be a fee, but a levy in the nature of the tax. Then next page, Balas, 333. Royalty on coal is a tax. Then, Malas, I move to B23. International Monetary Fund, Malas, not that it's at all in any way binding. It's a working paper. I've quoted that. Don't read it. It's saving time, Malas. I've quoted it there. Please look at it. Come to B24, which is on general interpretation, Malas. Your lordships can use an external aid, because these are some of these external aids to interpretation. And now, Malas, just note on the side of B25, a conceptual point, which is not put like that. Your lordship has taxes which are royalty under 9. This lordship I have not put here. Lordship I want to note on the side of B25. Royalty is a tax under 9. Dead rent is a tax under 9A. DMF is under 9B. Only thing which I get a quid pro quo and a benefit is the fourth one, NMET, the exploration tax. That is 9C. That can go in the category of fee, but it's an impost covered under 366. It's the fifth one, which came in 2015 in my B25 para, which is a bidding parameter. That is contractual. That is not a tax. This what happens is, Malas, after the auction regime of 2015, I have to bid. So I bid 10 rupees, he bids 20 rupees. On that bid of mine, depending on the bid, I have to give a share. That's my contractual thing. That's the fifth one, which has come only in 2015, which I've quoted in B25. All the other are compulsory exactions. I'm only contrasting it. It's called a premium, but it's actually a contractual exaction, a contractual payment. And that is the closest to a share or a consideration. I'm contrasting it, brothers. And your Lordship Malas has got the B25 and B26 on that. Now, Malas, I come to the other contrapoint. If it is a tax, Mr. Singhvi, how do private persons collect it? Very simple answer, Malas. Let me give the answer first and I'll read the rule. Well, it is true that it is a relic of the constitutional past. But Malas, the tail should not be allowed to wag the dog, as was mentioned yesterday. This will be a case of tail wagging the dog. It is a very, very few number of states, and my learned friend relies on Theresima. Mr. Devedi cited it, which was Kerala, which had forgotten, I would use the word forgotten, to pass a law saying that the mineral under the earth is the states. Incidentally, after Theresima, Kerala immediately passed that law. Most other states, 99% have that law. It is true that there may be one or two examples, which I call a tail Malas, that will not decide a 9 judges approach. That royalty is not a tax because 0.1% cases may be there in the country where the mineral does not vest in the government and therefore there can be a private lease for which royalty is paid. That's answer number one. Answer number two is very interesting, Malas, is that even in those private lease cases, the 2016 rules make it clear that it is completely controlled by the government. Because the private man, he's the private lease owner, he can't give me a lease. He has to go through a gamut of prior authorization by the government under 2016 rules, which I'll show in a minute. And the third reason is most important. This private leaseholder cannot enforce through 25. That's the hallmark of a sovereignty of a tax. So, Malas,
what is the third reason?
Third is this private fellow who has a relic, Malas, a few occasional leases here and there in the country which have not been taken over by the government, cannot use 25 to enforce. The enforceability is given only to the Malas exaction. Section 25 is clear. Now just read the paras in that light. 3 points I have given, Lordship. All three are covered here.
Sovereign function.
So B27
That is with regard
of
to
my page, Malas 334. .334 is the Theresima Kerala case.
Yes.
At B27. At 335 page number of my written submissions, I have said in the first 3 lines, there was an absence at that time of a provision in the Kerala land revenue declaring the ownership of minerals underneath to vest with the state. That is one of those anachronisms. There is hardly a place, 99% would not be there. It's a relic of the pre-constitutional position, which I have said. I don't want to read it. Second B28 is the section 25 point, which I just made. B28A, section 25 and 21 bracket 5, the recovery positions provisions would not be available to private lessors, thereby changing the very character of royalty. The grant of mining lease concessions by private person is not unqualified. Now see this authorization in rules 27. Where is it? This book you should have to take 2000. Actually, although the private man has the lease, he can't sneeze without permission from the government. All of it is regulated.
All right,
Rule 27 is not given here in this bunch, but your Lordship has that book.
Yes.
It's got a 2016 rules, which says for a private owner of a lease to even negotiate with him and give it to him, everything is covered by prior permission and authorization. He can't. And this is true of minerals other than hydrocarbons and atomic. In hydrocarbon and atomic, of course, there's no question. It is already gone with the state. But for all other minerals, every other mineral. So, it is a relic. It's an argument used to decide the main matter where 99% leases are not there and Lordship is, it is true factually. I can't deny it. But it just doesn't make sense to interpret it on that basis, my humble submission. Now, that's the 2 points. And lastly, as I finish my first proposition, just see that 4 months later judgment by the same learned judge who presided over India Cements and how he understood tax. Kindly see the Honorable Chief Justice in volume 5I, page 67. Starts at 65, at 67. He presided over India Cement. The learned judge who presided over India Cement, 4 months later in a smaller bench. Oh, come on, give it now, give it.
Choose that.
Pravji bhai, you have paper.
5I? 5I starts at 65, relevant at 67, para 6. And well, I will always hearken back to that question. What is so specially wrong about India Cements? Or what is so specially correct about Kesoram?
Which part is that? Of,
60, para 6 at page 67. That this entire established law should be changed.
Months after the.
I'm sorry, not 4 months, 2 months after India Cements. 2 months after India Cements. Well, the Chief Justice, as he then was, says, we do not find much substance in this contention. Does my Lord have para 6?
yeah.
Recently, a constitution bench of this court has held in India Cement. Recently is 2 months earlier. That the royalty levied on the extracted mineral was the nature of a tax and was not in nature of a fee, which could be used only for specific purpose. Any tax realized, etc., consolidated fund of India. I'm not reading, but it's save time. Well, all this is happening because a 5-judge bench, at least judicially, Malas, has set the cat amongst the pigeons. Unless there's some overwhelming reason why a lordship should not follow a 5-judge bench. Malas. Otherwise, the law was very clear, understood as clear. Malas, coming to my second proposition, I must race along, Malas. Dead rent is the second proposition. At page 335, it starts. Is clearly even a fortiori a tax. As your lordship knows, the scheme is central government occupies in 9 the royalty. In 9A, it starts occupying the dead rent. Well, I would like to call a dead rent an idling charge.
Is made to the government. Will a minimum guarantee payment also be partake the character of a tax? Because in a large number of situations,
Yes.
a minimum guarantee payment is assured to the government, whether it's an electricity company. Because the principle is you must lift electricity.
No. Its answer is very simple. I appreciate my lord's question. It's very important. Nobody can say a minimum guarantee.
Suppose if there's a public-private partnership. Government has once an assurance of a minimum revenue. It says this is you must give me this, irrespective of what profits you make.
Straight away. There's no problem. Every example which your lordship has in mind will be contractual. Every example. What are these public PPPs, Malas? One is a BOT highway. Second is a tender. Third is an auction. All contractual. This is, Malas, an exaction under 9A. Your lordship has a clear dividing line, and I'm not going to be inconsistent, Malas. I've just yet to show your lordship a very interesting statement of objects and reasons when 9A was brought in. Your lordship will be shocked. Every case will fall in the contractual versus the non-contractual exaction line. And that's why 366/28 is perfect. Chief Justice Latham is perfect in Chicory, followed by Malas, 1 9 judge and 1 7 judge in India, Shirur Math and Jindal. Now in this Malas dead rent, first of all, the points are the same, Malas, 3 elements: compulsory, non-voluntary, exaction, and Malas enforceability. Same. Here the additional point is, it is not based on what you extract.
Nature of a tax.
As a matter of fact, the better way of looking at dead rent is it's a charge on you taxation for squatting or for Malas idling. You just idle. Either Malas, my learned friend Tushar Mehta gave a reverse example. I would think the better example is that you sit and do nothing. He gave an example that you overexploit early. Suppose you do nothing. You are depriving this man from getting it. You are not contributing to the country and you're sitting idling. So dead rent comes in, irrespective of whether you extract or not. Now, Malas, in this, B31 straight away is extremely important. Malas, this also was, Malas, in Form K. It was transposed from Form K in 1972 and put in the section. This is apropos the Honorable Chief Justice, very important query. Of course, according to me, it was statutory even in Form K.
2E.
There was no doubt about it. But Malas, after 1972, the issue vanishes. It is made a special statutory provision with a capital A. That's by para 31, B31. Now, Malas, in 72, they brought in 2 sections together, 4 capital A and 9 capital A. I hope I'm clear on this. And the object, the SOR of 4A, which I am reading from the note itself rather than taking your lordship to save time, is very, very, very interesting because it replicates the language of 54. It reads, so as to enable mineral development of that area by a government, company or corporation. This is lots will get in volume 4, 915 and 916, but don't go to it. It will save time. It's quoted by me here. Well, 4A and 9A are related. 4A is lapsing, and if you don't, if you abandon the mine, lapsing, and 9A is squatting or well, is idling. Similar concepts. This is the object. This is the object. So, Malas, I think I've done my second issue, ending on Malas B32. Hence, there can be no manner of doubt that 9A was introduced to further mineral development in nature of a tax on mineral rights, thus qualifying for the limitation, etc., etc. I turn to my third proposition, Malas, which I use the very loose, and I said so myself, incorrect analogy. Look back. There is a phrase in private international law with that French word renvoi, which is look back. It's like a circle. You come like this, you come here, you reach here, and you look back. Well, it's 50 is a very interesting way of looking at 50. It's a look back provision. And let me accept. This was my third proposition is the entry 97, read with 54 proposition. Let me explain that and then I'll read the paras. Let me explain that first. Let me just explain that. Entry 50 A, I'm breaking it up now. And Lordship has seen the language many times. And your Lordship, very important to note the opening three words. Taxes on. That has been given less weight. The provision is focused on taxes. Now, when a provision opens with taxes and then follows with the word limitation, it has to contemplate limitation on taxes or qua taxes. Otherwise, the provision is meaningless. It will read very distortedly. Taxes on mineral rights, then of course subject to limitations, etc., etc. So the limitations. So point number 1, it is on taxes. Point number 2, it looks back to limitations of inter alia qua taxes by a superior provision. Entry 54 is the only superior provision. There is no other provision. Third, once it looks back to 54 and taxes are the subject matter, then 97 can't be ignored. Because you have to read 54 synergically. I am not reading 97 as standalone. 97 has no value standalone. But once 50 is looking you back into 54, then 54 and 97 must be read synergically. Because the whole of list 1 specifically put those words in 97. That when you don't find a specific word in my list 1, then you must use 97. Now, to that, the Honorable Chief Justice asked many times, what about 248.2? 248.2 says, provided there is nothing in this 2. Answer is very simple, brothers. I am now addressing your Lordship's 248.2. Answer is simple. If list 2 was a vanilla provision of taxes on so and so, then 248.2 will bar my argument. But entry 50 is not a vanilla entry. It's a unique entry which says I am myself subject to a superior power of 54 and 97. So 248.2 is satisfied fully in my favor. 248.2 protects a vanilla entry of a taxation in list 2. But if there's taxes on mineral rights, full stop, then I could not make this argument.
The only problem, Dr. Singhvi, is this. If you look at entry 97 just as it stands, you see, what you are arguing, there's obviously, it's a weighty point, that once there's a limitation on...
Entry, the advantage of us making all kinds of fellows, because the Lordship is a creative, there's no tabula rasa. Lordships can decide whatever fellows is.
Because, you know, entry 50 speaks of limitations.
Yes.
Now, if you are right, for that purpose, we have proceed on the basis that you are right,
yes,
to test the hypothesis that the limitation is provided by the MMDR Act. Once the limitation is provided by the MMDR Act, then the power of the state to impose a tax on mineral rights under entry 50 is denuded, right? Is denuded. if that power is denuded, your submission is that power to impose a tax on mineral rights has to be located somewhere. And if it is to be located somewhere, it is in entry 97.
54 read with 97. That's important.
54 read with 97.
Because otherwise, your lordship will be right. I mean, I don't want to have a standalone situation. The basic power 97 was meant to go
Entry
with
54 does not. Entry 54 does not cover the field of a tax at all. Right? The power then to impose a tax, it's actually, I'm incorrect because the lists don't confer a power. 245, 246 confer a power. But the subject of a tax, which does not fall within entry 50 then, or which is subject to a limitation under 50 by your submission,
Let me answer that.
has to go to entry 97. The problem with that argument is that entry 97 says, including any
other
tax
matter
not mentioned in either of those lists.
Including any tax.
Even if there is a limitation, even if there's a limitation imposed under entry 54 of list 1,
Yes.
that tax does not cease to be a tax mentioned in any of the lists.
No, may I answer?
The tax still continues to be mentioned
No,
in
no,
all of the
there's
lists.
a slight thing. I appreciate. Allow me. I understand my laws completely.
Right? Therefore,
97
that the power of the state to impose a tax is subject to limitations.
97 disapplies itself because mention is made in 50 is what your lordship is saying.
Otherwise, look at it slightly differently.
Yes.
Here, according to you, the states cannot impose a tax on royalty at all because of the MMDR Act, which covers the field, right? Because that's a limitation. Suppose, for instance, the parliament has imposed a limitation not of this nature, which according to you is absolute. The states cannot impose a tax on royalty at all, according to you. Suppose parliament imposes a limitation short of an absolute limitation, right? It, in other words, permits the states to impose a tax on mineral rights, but hedged in by condition 1, 2, on atomic minerals not exceeding 5%, on bauxite not exceeding 7%, on XYZ not minor minerals. In which case, it could well be argued that Parliament then retains the power to tax mineral rights bereft of the limitation which it imposed on the states. That can never be.
I understand my law's query. Allow me to answer. It's very important. The nub of this.
Entry 97. Entry 97 was introduced because the framers felt, when they framed the constitution, that in future there may be new taxes which we never knew of. They may not have contemplated those taxes. And exactly, service tax was goods and services tax.
Answer that. It's very
GST was not mentioned anywhere at all.
I was now applied squarely to this case. First of all, let's just keep MMDR aside for a while. I'm at one stage anterior. The simpler argument is 9A, 9, 9A, 9B, and 9C occupy the field completely. That occupation will be provided Parliament has the power to occupy. So I am going one stage before, against myself. 9A, your lordship will just leave aside 9A, 9B. Now, your lordship, as the Honorable Chief Justice, the heart of the query is that 97 says not mentioned. Clearly, 50 mentions. Therefore, 97 disapplies itself. I understand the query completely. Now, what is my answer to this? We have to start the sequence again and give me just a couple of minutes. Very important, but conceptually. Entry 50 deals with many elements, but two crucial elements for this argument: taxes and limited by law relating to mineral development. Now, I'm only answering my lord's query. I'm not going to the larger issues. 50 does two ingredients vital for my answer to my lords. One, taxes. Two, limitations imposed by law relating to mineral development. It can't be a limitation related to non-mineral development. Clear, Milas? Number 3. If 50 makes itself a non-vanilla provision, not saying taxes on mineral rights, full stop. But 50 itself says taxes subject to a limitation by law related to mineral development. The third step is, which is the only source of power for mineral development? Answer has to be 54. That's step 3. I'm breaking it up. Allow me to just develop this. It has to be 54. That's the only single source of that subject. Number 4. Having reached there, you are in actually only one situation, because it doesn't, 54 doesn't use the word tax. So why do you find, that's why 97 was created. If Parliament makes a law limiting relating to mineral development, which is a limitation, the taxing powers goes concomitantly with 97. Now the 5th point is important. The word mention in 97 is not to be read literally to mean if there's any mention. What nature of mention is there? What is the architecture of that mention? What is the form of that mention? What is the way you have mentioned it? Your Lordship's word mention would be correct if it said tax on mineral rights, full stop. That's the mention which will disable 97.
So you're saying 97 has to be read harmoniously with 50.
First and foremost, 50 has to be read harmoniously. 54, then through 54, that's what my Lord said just now. Well, the mention word, I understand what my Lord is saying.
That is the
that's the crux of the matter. That's why I divided it into 5 points. The answer is divided into 5 subpoints.
There's something in what you're arguing for this reason, that it can't be in the contemplation of the Constitution that then nobody can impose a tax.
Exactly.
Right?
There can't be a vacuum.
There can't be a vacuum in taxation, as there can't be a vacuum in legislation. On the one hand, because of a central law, the states can't impose a tax because it's a limitation. Then does that mean that even Parliament cannot impose a tax? I mean, there is a point which we'll
that is,
on that.
Of course, well, if your Lordship holds it to be a different kind of entry 50 than what we are saying, then the matter is different. Your Lordship has to consider this part of the case, which is that 50 is a very unique entry. It is clearly looking back at 54.
Which also then leads us to one more question.
Yes.
All those levies which Parliament has now imposed under the MMDR Act,
yes,
nobody's challenging those levies, of course.
No, they've been challenged in
somewhere else. But under what power did Parliament impose those levies?
No, it is 54 and 97. Ultimately, no, now judgment is said so. Problem is Kesoram. Mahalakshmi said exactly what I'm saying. The problem is, Kesoram came along and ignored number of judgments, including Mahalakshmi. I would like to claim novelty and ingenuity. I can't. Mahalakshmi has much of this. Kesoram, with respect, could not have said the cat amongst the pigeons on this basis. I've quoted Mahalakshmi. Allow me to read that. Well, Honorable Chief Justice will kindly allow me. This is a very important question dealt with by our Lordships directly. It is only Mahalakshmi which is a dissonant voice. My Lord has been consistent. Let me give you those 4 or 5 cases in a minute. So now, I'll be reading now from 11 onwards very quickly. This is the whole case. Now, on this point, these paras will show Lordships that I am not able to claim ingenuity or novelty. This has been
You're proceeding on the basis that royalty is a tax.
Yes, that's a set of arguments.
Yes, suppose there's another perception.
Yes.
If royalty is not a tax, of course, in the subsequent judgment, they said it is akin to a tax.
Yes.
It is an exaction, but not a tax. Then what would be your argument?
First of all, akin will not make a difference, but 366/28 will make it. But let's forget that argument. Yes.
It is under the grant of a lease.
Yeah.
It is for exercise of a mineral right.
Yes.
But it is not a tax.
Yeah.
Then what would be the argument? The state's power under entry 50 remains, while under the Parliament, royalty may be imposed.
That is why I said that would be a acceptance of Mr. Dwivedi's argument and a repulsion of Mr. Salve's first part of the argument. But in my case, even then, dead rent is not answered in my Lord's query. What about dead rent? Remain a tax.
In India Cements, they included the word royalty.
No, dead rent is, sorry. Go for it.
In India Cements, the problem arose because they included the word royalty in the definition of that particular impost or cess.
Well, with with respect, I'll read those two paragraphs. Mr. Ganguly will read that also. Straight away. Para 34, India Cements is not. Allow me to answer. No, straight away. Yes. May I say, India Cement, independently on first principle, holds royalty to be tax. Directly and clearly, not because it's included here or there. Then it says, cess is another kind of tax.
Yes.
Therefore, tax on tax is bad. But royalty is a tax is independently on first principles held by India
It
Cement.
stems from the fact that the word royalty was included in the definition
No, but
Yes.
respect, no. I'll show that.
of the State Act.
But it will make no difference. But obviously, a tax of any kind will have to have some statutory basis.
Yes.
Under Article 265, your lordship cannot have. So it has to have some backing. But the basis is therefore statutory in the not the strict sense, but let me say sovereign levy, exaction, and enforceability. Your lordships cannot have a tax. Well, suppose I contractually demand something, it won't be a tax. So that much will be there always. But India Cements is directly holding it to be a tax. It is holding it because it is an exaction. Of course, they had a separate question. The first para puts it that is this cess on royalty valid? So cess on royalty makes it worse. It's already a tax. On that you put another tax. So that's the issue. But to come back to this, dead rent is a good example because dead rent is a for sure a tax. Tax, dead rent is a for sure a tax because it's an idling charge. You do nothing, you still pay it. It's a compulsory, it's exactable, it's enforceable, no option.
Dead rent is a tax. Dead rent is also very intrinsically related to royalty. That's why the proviso to section 9A1 says that when the holder of a mining lease becomes liable to pay royalty, he shall pay either royalty or dead rent, whichever is higher. So it is really in the nature of it's for the exercise and therefore non-exercise of the mining right.
Let me answer that. With
It's
respect.
relatable, it's relatable to the exercise of a mining right. Dead rent, your concept
No, with respect,
that this is a tax may not be correct.
It is no, with respect. It's conceptually the very same point I'm making. It has to be related to royalty because if you mine and extract, you will pay royalty. Now, if you don't mine and extract, you are squatting, which is why you pay dead rent. It's an idling charge. I started by saying that.
Tax.
Well,
it's a charge which you pay to the state for not having exercised your right to extract, and therefore the state is losing revenue.
It's not optional.
And therefore, you have to pay.
It is. So, what is the? That's why 36020 impost. What characteristic of a compulsory does it not have? It's compulsory. It's 9A. It can be enforced by 25. The man can't, and the rate can be changed by amendment to the third schedule. Your lordships can't change the rate without amending the third schedule. It is completely a tax, brothers. And the whole idea of putting 36628 was to catch those minor creases which said that no, it's not a tax in a full form called so. Well, your lordships can't change the rate except a third schedule amendment. And 25, same recovery procedure. So
9B5, which is the District Mineral Foundation, and 9C4, which is the National Mineral Exploration Trust. This is all paid as a component of royalty.
No, with respect, it is alternative.
Instead of passing this 9B and 9C, they could have just enhanced the rates of royalty. They put an additional provision.
Let me explain.
It doesn't cease to have that connect with royalty.
9A, 9B are all taxes.
And
9C can be a fee.
Assuming royalty is a tax.
Yes.
Where is the bar on the states imposing a tax on mineral rights? Because it's still in the nature.
That's my fourth proposition. That's coming. That's my fourth proposition.
There's no bar on the.
I am conceding. Let me shock your lordship by saying my fourth proposition. Say I concede that, but you are not levying a tax on mineral rights. For a minute, for the purpose of argument, let me concede that you have a right to. I'm not accepting anything. Concede the fact that you have a right to levy tax on mineral rights. Allow me. That's my fourth proposition coming up. But let me finish my third, brothers. My third proposition, therefore, rests with 9, 9A, and 9B. Kindly read them carefully.
So what is the proposition in section 9?
This is my proposition number 3, Malus, at my first page,
How
320.
do you formulate it?
Yeah.
9,
9A, 9B
Yes.
are taxes because they are compulsory imposts by a public authority enforceable by coercive measures, bracket e.g. land revenue, etc. And are changeable only by statutory amendment. There is nothing else a tax has, brothers. No tax will have anything except this. No tax. Otherwise, the whole concept of tax will change. And if 7 judges in India have held so, why should a lordship depart unless there's something fundamentally wrong? This was accepted by India 7 in so many cases. It's just that Kesoram has created this new thing. 9C is, however, a fee because there is a quid pro quo of exploration. I myself said so in my note. 9C has an element of quid pro quo and is a fee. It's an exploration issue. Third point was, apropos the Honorable Chief Justice's query. Two more sentences on this, Oliver. 9A, which is dead rent, has to be alternative because when you don't mine the land and extract minerals and squat or waste time or sit there idling, then dead rent comes in. So the very concept is in the alternative. That's the concept of it. The whole idea is that you must mine.
All right, there's a third point now.
And the last as well is that some of these calculations in 1 or 2 of these cases is done by a percentage of the royalty. That's a calculation. That has nothing to do with changing the character. It says that you will pay at X percent of the royalty. This first completes my third point, but the most important part of the third point is the look back nature, non-vanilla nature of entry 50. I've done proposition 3 minutes. Proposition 4 is what my Lord the Chief Justice just now asked me. No, I'm sorry, Malas, I have not finished. I have to read very quickly this previous point. Please turn to A11, Malas, page 310. I was conceptualizing it. I have not. This will be very quick. I'll just read it very quickly. On the previous point, Malas, that is on this 50 look back and 97. Come to Malas para A11 at page 310. This I had to read, Malas. Extremely important. Such important judgments are completely, Malas, put to the side by Kesoram. That's the only reason, Malas, your lordships have to exert. Please turn to Malas page 310. Does my lord have it? All my lords have got it? Yeah. Now just I will read the bold face only, Malas. I'm skipping. This is Mahalakshmi. Once the parliament has occupied the field in connection with regulation of mines and minerals development, and when the parliament declares it is expedient in the public interest to do so, entry 23 of the state list regarding regulation of mines and minerals would be of no avail to the state legislature, as entry 23 is subject to list 1. Nor will entry 50 be of any assistance in this case. Kindly go further, the bold portion. Once these entries are out of the picture, it is entry 54 in the union list which will operate, and the imposition of tax on minerals extracted would be squarely covered by 54. Now come to the next page. Section 9 being part and parcel thereof cannot be out of the sweep of 54. However, even assuming that there should be a specific taxing entry regarding taxing of royalty on mineral rights, which can sustain such legislation under the said entry, being a topic of legislative power, we find that there is no such specific entry in union list, nor in state list or concurrent list, which can be of any assistance in this connection. Entry 50 in the state list is out of the picture. That's non-vanilla entry. Then, Malas, in the alternative imposition of such hybrid tax on mines, on capital, on labor, would be covered by the residuary entry 97 of the union list, which empowers the parliament to enact laws on topics not covered. Now go further, Malas. It is not a flash in the pan. It is not, Malas, one swallow which I want to make a summer out of. Come to the next judgment, Saurashtra. Yes, that's it. Now, no, that's it. No, I'm going to cite it. Now, the next para is Saurashtra. This is not that Saurashtra. This is the Supreme Court Saurashtra. Yes. The other one was the Gujarat High Court. The boldface. Section 9 and 9(3) thereof, by holding that by entry 54 of list 1, it was within the legislative competence to make the law in question, neither 23 of list 2 nor 50 of list 2 would be attracted. It is no doubt true that in the aforesaid case, that is Mahalakshmi, aforesaid case, the court also held that 97 will confer legislative competence, but not because Parliament has no competence under entry 54. They went further. 54 is enough, but it was used as an additional prop. I hope I'm clear on this. They say 54 is enough. 97 is an additional prop. Now let us come to A15. Kannadasan, I'm not citing, Mr. Salve was dismissive of it. I'm not citing for that purpose at all. I am citing that when your lordships had so much collections and you had to help the states to not get refund, you passed Kannadasan. You passed the Validation Act, and it came for Kannadasan. Look at these highlighted paragraphs. Shri Sanghi argued that the denudation is not absolute, but only to the extent provided in the MMDR. Section 9, Learned Counsel submitted one of the facets of the extent of denudation. This partly will deal with the extent argument also. This contention assumes that notwithstanding the declaration in 2, the states still retain the power to levy taxes upon minerals over and above those prescribed by the MMDR, and that a fresh declaration is called for whenever such subsisting power is sought to be further encroached upon. That was the original argument. Each time you must have a fresh declaration. Then 313, page 313. The denudation is not partial, it is total. They cannot levy any tax or cess on minerals so long as the declaration in section, there's a misprint there, 2 stands, 2 is missing. Once the denudation is total, there is no occasion or necessity for any further declaration or, for that matter, for repeated declarations of denudation. Now, let me make the submission after I finish. Come to para 17. Even assuming without conceding that the declaration in 2 does not ipso facto oust the state's legislative competence, I'm arguing the alternative. Expressly contemplates the levy of taxes thereunder as evident from section 25, and the fact that it levies a royalty, which is a special kind of tax, under 9 and a dead rent under 9A, denudes the states. Conclusion in 18 is very important. Conclusion. Thus, even assuming entry 50 is to be read restrictively so as to require an inquiry as to whether any specific provision imposes a tax, 9(1) imposes tax, directly covers the field. 9A imposes dead rent, directly covers. 9B imposes a cess to be employed for upliftment of the district affected. I'm on the next page, Manas. And Manas, your lordship will just allow me, this Pradhan Mantri Khanij Kshetra Kalyan Yojana, which is at page 47, is very useful. It'll repay study. I don't have the time to show it. Please make a note and please see it, Manas, at your lordships. The center covers the entire gamut and tells you how to use the money till the last user. This Pradhan Mantri Yojana, Manas, is page 57, is very comprehensive. And it is issued under section 20 capital A of the Act. So here one sentence. This extent will not have any problem here because coverage is complete. The coverage cannot mean multiple piecemeal legislations. I gave the example of the coat and the gown and the band yesterday. You cannot have multiple legislations that because I covered the coat and the gown, tomorrow, Malas, somebody can do on shoes. That, Malas, its intention is to leave that to the center and not tax it. There is an implied prohibition there clearly. Then, Malas, para 19. Now, Malas, just see. Odisha Cement says, all these are ignored, Malas. I mean, not ignored, they're just brushed aside, cited and brushed aside. The object of 9 cannot be ignored. 25 implicitly authorizes the levy of rent, royalty, taxes and fees, directly the issue. But if your lordship total the number of judges who are spread over India Cement, Odisha, Synthetics is coming. All judges have the same view. I mean, your lordship is of course plenary, but why should your lordship give so much weight to Kesoram? This is the only dissonant judgment. Now see the next one. Synthetics is very interesting. My lord is hearing synthetics on the other point of entry 3 list, entry 33 list 3. This is a different point, very interesting. 7 judges held so. 9 or 7? 7. Now see, Malas, Mahanadi. So Odisha I have done in 19. Now see 20. 20 is Mahanadi. A perusal of the MMDR, all the sections are given, will clearly point out that taxation on mineral and mineral rights, any tax, royalty, fee or rent are provided in the said act. The state legislature is denuded or deprived of the power to enact. Then 21. Well, these are calculations I've given. Your Lordship may just keep it in mind. I will save time by not reading it. I'm only adding to Mr. Tushar Mehta as well as impassioned plea about various monies where they go. The last part of para 21 is very interesting. He's given you the details. I don't have to go. That's the government's job. But we'll just see all these total to about 16 to 21% of the average sale price. Last line was above para C. Above para C, my lord has got. All my lords have got the line above C. Total of all these levies, which is 9, 9A, 9B, 9C. Of this 21 or 16%, 0.3% is retained by the center. The previous line above that. That is 2% of royalty NMET. That is 0.3%. All the rest goes back. Now let's see next para C at page 315. Most significantly, all these levies except NMET, that is 0.3, admittedly go to the state government coffers. Then Malas, state-wise breakup is given. Mr. Mehta has dealt with it. I'm not going to deal with it. Two more para that I'm done with this part. Malas 23 at page 316. Now Malas, it is true that the general standard Sundaramaya Iyer concept of grouping is there. Before I read it, my answer is simple. That is not a mechanical sorting machine. Where this article leads you, Lordship, to think differently, that is 50 special unique architecture, then that grouping is not cast in stone. That's my submission in 2 paras. Sundaramaya Iyer is valid, but it says itself is not exhaustive. Sundaramaya Iyer, that judgment which says grouping, that says itself that you don't treat it as exhaustive. There may be entries like 50 which don't allow grouping because they're uniquely worded. My Lord Malas, if I may say, called it 8 mantras. Honorable Chief Justice 2 days ago. Malas. I've dealt with that. Let's kindly come to 823. You have to, therefore, not be a slotting machine. You have to go entry wise. Mostly Sundaramaya may apply. Sometimes will not apply. Your Lordship's analysis or interpretation can't be straight jacketed by a Sundaramaya focus that no, I have to group. This is a unique architecture. This one is not a grouping architecture. It is 54, 97, 50. It's a totally different triangle. Now come to verse 23. For these reasons, 50 and 54 read with 97 imply a sui generis and complete code on regulation of mines and mineral development and taxation of minerals and mineral rights, as the state's power of taxation in entry 50 as well as general powers are both subject. Both is italicized. Then let's come to 24. 26. I'll skip 24 to save time. Come to 26 straight away. This is, the word mantra is replaced by the word sutra here. The Roy's case from Assam acknowledged that the scheme of the 7th schedule cannot be governed by a straitjacket. Our endeavor is, because he goes against the Guire principle. The Guire principle is grouping. So he says, no, it can't be a straitjacket every time. Our endeavor is only to demonstrate a great deal of examination, etc. No rule which has a universal application with regard to the interpretation of all entries can be postulated. That's my point. That's my respectful submission. The statement of Justice Guire, Chief Justice Guire, that a broad and liberal spirit should inspire and the legislative entries should not be read in narrow, cannot be understood as a sutra valid for all times and in all circumstances. That's the only point I want to say, Malas. And Malas, para 26, next page 318, I have mentioned the 8 mantras, 8 formulations which the Honorable Chief Justice has done. I am Malas now coming to 27, which is a little noticed, but an extremely important paragraph, 827. 7 judges in synthetics, not on the point your Lordship is considering next week, say the power to levy taxes is to be read from the entry relating to taxes and not from the general entry. Exception in entry 50 of list 2 where tax on mineral rights is subject to any limitation imposed by Parliament relating to mineral development. And this power of Parliament is in general entry. There can be no more direct than this. Now, you may say, Malas, as 9 judges is wrong or right, but certainly, Kesoram, with greatest respect, had no business to brush it aside. Then, Wallace,
See, the power to impose a limitation has to be read under entry 54. That doesn't mean the power to impose a tax is to be read under 54,
Two-
read with entry 97.
two answers, Wallace. It means a tax because of the language of 50. That's the opening word of 50. 50 cannot contemplate a limitation which cannot be a tax limitation. Answer number one. Answer number two. 7 judges have said exactly what I've said just now.
No, it's a limitation on the power to impose tax.
No, tax it says. Synthetic says tax.
Yes, the limitation on the power to impose tax
Yes.
means the power resides with the state. The limitation emanates from entry 54.
Yes.
Correct.
Therefore, the power resides in the center also, Wallace. The
Yes.
center cannot impose without all the power, Wallace. The power has to be in the center, Wallace. And a superior power is the center.
I'm trying to say
Yes.
is the power to impose a limitation doesn't take within itself the power to impose a tax.
Wallace, with respect, let me examine. That's a new nuance, my lord. Give me 2 minutes. Wallace, how do you limit a tax without reducing or imposing? Suppose the state imposes 1%. I want to limit it, I say abolish it. Your lordship has to assume that I have the power. If the center has no power, the matter ends. Your lordship will not be able to control it. Limitation has to include from 0 to 100.
Can say we are abolishing the power of the states to levy the tax,
Yeah.
but we are going to levy the tax. That's not the scheme of the constitution.
No, by 97, they will have the power. Wallace. If your lordship resides the power, it has to have the power. With respect, Wallace, with respect, that will be an artificial limitation. No, Wallace, let me just explain.
Very
Let
clearly,
me explain, Wallace.
it is very clearly divided, Dr. Singhvi.
Yes.
The state is given the power to levy the tax,
Subject to limitations.
subject to limitation. We understand that. And we go into the 54. But you are trying to bring in 97 as also a power to levy tax. How can the residuary entry be utilized for this purpose?
Can I? First question to be decided is, does the center have the power or not? Matter ends if your lordship finds they have no power on taxation. That's the primary question. All this debate is if they have some power of taxation. My answer is they have to have a power of taxation because the limitation envisaged and recognized by 50 itself is a limitation on taxation. 50 itself recognizes that you, my superior, has the power. We stop here, Wallace? Unless the at 50. I know this is
Yes.
too late in the day to look at 50, but let me give you Lordship 1 minute. Taxes.
मराठीत अस्मिता म्हणते ना, अस्मिता आमची पॉवर आहे. The next
Yes, very well,
topic
very
now.
well. Only one sentence and I'm done. I've made my submissions here. Lordship may or may not will. I'll go to the next point. I only want to say one thing.
Movement of looking back, Dr. Singhi.
Yes.
It might be seen by the states as looking back with anger, you know.
Super hit it was, Willis. Now, Willis, one sentence and I'm done. I'm going to the next point.
By Uza from India.
I'm coming to my next proposition with one sentence in the last one. There are therefore, in summary, 5 judgments. What should be note on the side is not in my note. 3 of them locate this point in 54, read with 97. I'm summarizing now. Those 3 are Mahalakshmi, Saurashtra, and Justice Sinha dissent in Kesoram.
Just one. There are 5 judgments. We locate the power of Parliament to levy a tax.
Yes.
on
Under
in-
54, read with 97.
and you have given those as Mahalakshmi,
First is Mahalakshmi, then is Saurashtra.
then Sinhaji's dissent in.
And the 4th is important, Odisha, which is quoted in my page 311. I'm saving time, a very useful quotation. 4 judgments. I'm sorry, that 4th one is, I'm sorry, that's an error. Justice Oza in India Cement, I meant, not Odisha. Justice Oza in India Cement,
Not Kesoram.
not Odisha. No.
Oh, yes.
Justice
Oza
Sinha
in-
is
Oza
dissent
in India.
Kesoram, and Justice Oza, because he was a concurrence brothers, in India Cement.
Yes, we saw that, I remember.
And there is one more judgment which does the same conclusion without 97. Without 97, which is Mahanadi plus synthetics. 2 judgments. I'm sorry, 2 judgments.
Mahanadi,
And synthetics. They're all quoted. So my lord has 6 judgments in all, 4 which do conjointly 54 and 97, and 2 which rely on 54, but the same conclusion, taxation. My question remains the same to myself, Willis. Why should Kesoram be preferred? Just finding it. Interested. 10 minutes more. This is an important proposition for your lordships to lay down guidelines. It is dealt with from 319 to 322. 3 pages only. Let me make the point, then your lordship doesn't have to spend time on it. I only want to ask your lordships, again without prejudice, 3 pages, 319 to 322, that your lordship should make it clear what is the tax on minerals versus what is the tax on mineral rights. My first principal points are twofold, then I'll just read 1 or 2 paras. 50 is advisedly using unique words. I always call it a non-vanilla entry, because no other article in minerals, in Vala's entries, has used tax on mineral rights. 53 and 54 use mineral development. 23 uses regulation of mines and mineral development. 54 uses identical language. Now, Malas, my point is, that your lordship should give some weight to that different language used. And one more sentence factually and contextually. Well, there's a fundamental difference. One is you tax my extraction from the bowels of the earth. So 10 tons, ad valorem fee, 5%. Whatever the value, sale value, you tax. 100, more tax. It's a fixed ad.
So tax on minerals.
Yes. It's very easily understood.
Tax on mineral rights.
And in contrast, I give him a lease for 20 years. I give him a lease for 50 years. And I give him a 100-year lease. Or I give Manas different forms of licenses. I don't know all forms your lordship has of, along with size. You can tax that, but that's a different taxable event. The nature of the tax is different. I'm not saying you can't tax this. In this argument, I'm conceding without prejudice argument naturally. Without prejudice argument, I'm assuming that you can tax, but you please tax mineral right. That is the duration and the size which you have to extract minerals, not the actual mineral extraction. The grant can be taxed. This has been held, Balats. Incidentally, again, these are all Balats upset because of Kesoram. This has been directly held by 3 persons at least, Balats. The same Justice Oza concurring in India Cement. It's all quoted in my note in these pages. Justice Sinha in Kesoram and Justice Vanchu in great detail in Hinge. That's the most detailed. I'm going to save time by not reading it. I would request my Lord, those paras repay study. My respectful submission is, what is so conceptually wrong that your lordship should incline to the Kesoram view? Kesoram has cited them all and said, because India Cement had a typo and an error, therefore all these judgments are wrong.
But royalty is not on, is on the mineral removed or consumed.
Exactly.
It is on the
Exactly.
product.
Exactly. That's my point.
But a tax on mineral right is under entry 50.
Correct. So your lordship, please
You
lays
should
down.
say that royalty is not a tax on mineral right, but a tax on the mineral removed or consumed. Then there is no dichotomy at all.
That's all I'm asking for. With the deepest respect, that's my formulation. But I can't say it, your lordship has to say it.
So you are saying that
I
if
think
the
that was
states
it.
impose a tax under entry 50, you can tax the grant, but not the extraction of the material. That's your contention.
This is a more pithy formulation. Tax on minerals extracted, dispatched or removed are not part of 53. Not part of 50. And 50, as my lord puts in a different form, I didn't
But
use
it
the
can
word
be used as a measure.
You can't. A measure can't change the taxable event. A measure can't change the taxable event.
Taxable event is your right to extract.
Extract, which is not the mineral extracted.
But the state legislature may say, okay, I will impose a tax which will be a certain component of royalty.
Whereas once
Right.
your lordships,
Your right to extract is not really something in the abstract. Your right to extract has meaning because of the commercial exploitation of the right. So the legislature may use a number of formulations because a number of formulations are open to the legislature. It may say, all right, we will tax at the rate depending on the number of years of the lease or the quantum of the area or the size of the grant. Or we can also tax on the basis of the actual extraction as a measure of the tax.
can I just,
Because that's the commercial use to which you are putting that grant.
no, my lord is simply putting that the
Say that
measure.
tax on mineral rights should have no connection at all
No. I'm
to
not
the
saying that.
exploitation of the mineral
No,
rights. Maybe a little too far-fetched.
Well,
It's a legislative
well,
issue. We
then
must
your lordship would
consider
be,
it in the broadest possible
then your
terms.
lordship would be allowing a camouflage.
It's a field.
No, may I answer that? Your lordship would then be allowing.
And it's not this, that a tax on minerals is given to parliament and a tax on mineral rights is given to the state legislatures. In which case you would clearly have to restrict taxes on mineral rights by excluding that which is given to parliament as a tax on minerals.
May I answer?
Here the entire field of mineral rights is given to the state.
May I
And it
answer
is
both the
subject
points?
to limitations which parliament
May I answer both the points? Point
number
number one.
and regulation and development.
Point number one. Well, your lordship will not allow a legislative subterfuge. It's most established principle and axiom of tax law that by camouflaging, you cannot use the measure.
Therefore, Dr. Singhvi, is that look, you can only tax the right to extract minerals.
Your lordship put it
But
differently.
it must
Grant,
have,
grant.
it must have no nexus at all with the actual
Oh,
extraction.
that second point, you're right. I'm saying something else, fellas. Your lordships can let division benches decide the individual case, but your lordships as 9 judges must lay down that what you are given an entry is only mineral rights. Mineral rights can't be equated with minerals, but that will let's say subterfuge. A taxable event can be changed by a measure completely. Now, just see, Manas. A grant is well understood. Your lordship taxes, Manas. I mean, in the very minor sense.
Forget this area for a moment. Huh?
Property
Let's
tax.
go back to basic
Property
principles.
tax.
State can levy stamp duties.
Yes.
Well settled principle of law that a stamp duty is never a tax on the transaction, but on the instrument. It's very well settled since independence. Now, all states, including Maharashtra, from where both Brother Oak and I come from, while levying a stamp duty on an agreement to sale, they use the measure of what is the measure which is used? The market value of the property.
I appreciate.
Right?
But does your lordship know clearly the difference? And that, no, but that's the problem. But your lordship clearly knows at that point the clear difference between stamp duty and any other duty. Today,
you are right.
excise
You are right. We'll have to
duty-
tell the states. We'll have to tell the states that look, you can levy a duty only on the instrument and not the transaction. So the underlying market value of the asset which is transferred, you can't use at all as a state.
I'm asking myself,
That's barred to you,
if the
sir.
test
We'll have to
laid
tell
down
the
by
states
the
that.
9,
This can never be.
no, if the
Once
test,
a field is given to the states or to the center, you can choose any numerous formulations the legislature can frame.
the field given is by unique language limited to tax on mineral rights. The field given is not a tax on minerals. Your lordship will not give them a field wider than that is given. And today,
The measure can always be suitably.
measure cannot change the.
The only little caveat is what RR Engineering said, that your measure should not assume the character of the
No,
tax.
I am saying, if your lordships will lay down the guideline, then the division benches will decide in a particular case. But the guideline cannot be that, today you can camouflage a mineral tax, a tax on mineral rights, by levying it on the entire extraction of minerals. That will change the character of the tax. Your lordship has to only lay down the guideline, as two of my lords have formulated. The actual thing will have to be seen act by act. But what is given, this is on the assumption that the states are given something. The states are given a taxing right on mineral rights. They are not given a taxing right on extraction of minerals. Why has entry 50 not used the words of 52, 53, 54 or 23? Is my question to myself. Why has entry 50 used unique words not in 52, 53, 54 and 23? It's as simple as that. And 9 judges should, referred or not referred is not the point. Today, the lordship should lay down this guideline.
Now your argument comes to this.
Yes.
57 Act does not take away power of the state legislature under 50.
Without prejudice. Correct. No. They go on taxing on mineral rights only.
50 is mineral rights, tax on mineral rights.
But the whole question is, what is mineral rights?
No. So therefore your argument is
Yes.
57 Act does not take away the power of the state
No,
legislature to
that
levy
we are-
taxes on mineral rights.
This is an alternative argument, assuming that we are wrong on the earlier arguments, that you must limit this to mineral rights only. That's obviously a without prejudice alternative argument. If I'm right in the first argument, they have no rights at all.
And therefore, your contention is that it should be only a tax on the right to extract.
That's right.
And must be agnostic to the actual extraction.
That's all. In whichever way a lordship frames it, grant or whatever.
We can't restrict the
Then
power of the
the next,
legislature. We can't do it to Parliament. Likewise, we cannot do to the state legislatures also.
your lordships in interpreting 50 can interpret the language of 50 and say so clearly. Your lordship would be allowing the grant to be governed by something which happens post extraction. The language of 50 which we are interpreting is very clear. Please don't allow it to be expanded without prejudice. The fifth and the two last points. The fifth point is at pages 322 to 324, 2 pages. This is settled by 2 constitution benches, Hingir and Tulloch. They are quoted in A47 and A48. It's a very short 2-minute point. Once 23 is denuded, then 66 cannot lie because 66 is a piggyback provision which lies with 23.
Once
That's-
entry 23 of list 2 is denuded,
Then entry 66 square fees.
entry 66.
Yeah, entry 66 is the entry for fees, list 2.
Oh, the fees. Yes, yes, yes.
Pro tanto gets eclipsed or inoperable or inapplicable. The judgments are clear, Mullahs. My paras, the Lordship will note, are 47, 48, and 49 at 322 to 325. They are Hingir, Constitution Bench, Tulloch, and Mullahs. Mr. Sirvai has clearly, very unequivocally in his usual style in A49 of my para. I've quoted that. Said so. Not that Mullahs, any one person is dispositive, but this is Mullahs in the same trend. Now, Mullahs, the last point. Yes, I'm sorry, this should be said. The reason for this fifth point of 66 is para 110 of Kesoram. That will be, Mullahs, with great respect, ridiculously broad. It says all fiscal levies. Then your Lordship will have validation of all fiscal levies by whatever name called, including 66 is a fiscal levy. Para 110 of Kesoram says all fiscal levies is clearly overbroad. And your Lordship is now laying down the law for. Now, lastly, Mullahs, just turn to page 338. This will take exactly 5 minutes. It's a very interesting 10-page analysis of Kesoram. I'll read less than a page and a half.
320,
Scattered.
338.
338. Mullahs, Kesoram with deepest humility and this is grievously wrong. It's not wrong, it's grievously wrong. And why is it so?
Grievous.
Again, it doesn't matter. Your Lordship is 9 judges, but your Lordship should know this because it is really. So first para is C 1.1 at page 338. A point obvious, 5 judges cannot effectively overrule or sideline 7 judges. That's an obvious point. I've cited the case law, not required. That's my para 1.1. They had to refer it. With this kind of surgery, they could not have said 5 judges, we are interpreting, we are distinguishing. It's completely changing. Second error at page 339 of my note. The typo point is answered by C point 2.2 and 2.3 at 339. Mullahs, I can understand your Lordship saying something. With the para quoted by me in C 2.3, how can you say, Mullahs, that it's India Cement held that royalty is not a tax and by typo it became a tax? You can say that conceptually I don't agree, I refer to. This will redefine the word typo. That is C 2.2 and 2.3. India Cement is saying with guns blazing categorically. And I've just read a 2-month later judgment by the same person who presided over India Cement, saying that we held that royalty is a tax. Third error
Into a tax.
is C 3.3 at 340. What is the errors I explained in much more detail? I'm only pinpointing 1 or 2 paras each. Well, as it says, and this is where is something grievously wrong. It says that India Cements looked at 2 High Court judgments, Mysore and Patna. And then it also looked at 4 other judgments. And India Cements is wrong because it really intended to follow 4 judgments. Now, this is answered very clearly in C 3.3. My Lord is ticked. Those 2 judgments are given. 3.3 at page 340. Don't read it. Go to the real relevant parameters. 4.3. India Cement noted 4 lines of cases and 2 lines and said we prefer 2 lines. I hope I am clear on this. That's 4.3. What your Lordship prefers is not the point, but Kesoram can't say in 5 judges that India Cement overlooked 4. And why did it choose 2? It cited all the 6. It cited 2 left and 4 right and said we prefer the left. Why can't it say so? And who is Kesoram to say so, Manus? Then, Manus, the 5th error is at 5.2. This, Manus, they say they brush aside India Cement in Manus Kesoram. I've given the Kesoram paras also. That was India Cement was a case of cess on royalty. And therefore, there's no occasion to decide royalty is a tax or not. But Manus, that forgets. See, in this, you will only tick 5.2 and 5.5, only 2 paras. 5.5 is Manus at 343. They were no doubt dealing with a cess. But the para says cess is a tax, royalty is a tax, therefore tax on tax we don't accept. It says clearly, the paras are quoted by me.
Now we've seen the matter as
Very
a
well.
matter of first
Very well.
impression. So
I'm done, Manus.
thank you, Dr.
And
Singh.
lastly, Vasila, I'm deeply obliged. The Lordship will see the written submission for the few things
Yes,
I've
sir.
left out. I'm very
Thank
deeply,
you, Dr. Mr. Ganguly.
I'm very deeply obliged for the
Thank you.
accommodation on time also.
Yes, Mr. Ganguly.
Should have.
So the parties I've appeared for, I've given here.
This is my first point. And for your kind consideration is what is the scope of 50? Because 50 also has a reference to law made by parliament with reference with regard to a subject matter, that is mineral development.
But even your first proposition may not be, maybe a little overbroad, that a law made by Parliament under entry 54 of list 1 subsumes the entire content of entry 23. That may not be correct. Because then that would be glossing over the words to the extent to which.
Quite right.
To the extent Parliament has covered a field under entry 54, that field is taken out of entry 23.
I agree with your lordship's observation, but only one thing I was wanting to say, no one has suggested to you that something else is left out in the 23 which is not covered, but this is a broad proposition.
Right.
Which is an accepted proposition. If there is some issue, somebody can say, no, there is still some, if it's left in 23, it's all right.
Yes.
But no one has claimed that they have such a right. And you know, the decisions of this court, starting from Hingiri Rampur, till Millard India Cement, all of them say so. That entry 54 really subsumes, covers the entirety of the subject matter of entry 23. There is no caveat on that at all. Now the question is, Millard, 50 is a tax entry, no doubt. And that is how, Millard, the arguments were advanced from the state, that look, you go by what the Supreme Court has said, Millard, since Sundaravai, that tax entries are independent, other entries are general entries. Tax entries are not governed or controlled by this is true. Millard. That's the arrangement of the broad arrangement of the Constitution and various items in the 7th schedule to the Constitution. The broad classification. So there I was not considering, Millard, are there any exceptions at all? First, they were not considering that. Broadly, you see the tax entries are separate. The general legislative entries are different. They generally they don't overlap. But 50, everyone has accepted, Millard, that 50 is a sui generis provision. It is a tax provision, no doubt, but it allows a law made by Parliament, which is not with reference to a tax entry, to control it by laying down limitations. A limitation, Millard, I think is the word of the word is used of wider import. Limitations will not have no limitation. Limitation would mean any kind of limitation, any kind. You know, how the Parliament would have visualized, Millard, we cannot. from time to time, you can only test the parliament's power when it has exercised that power of limiting the scope of entry 54. Whenever the matter comes up before a lordship's milord, you will test it, whether it is limiting or not limiting. But there cannot be, milord, a broad theory that limitation means only A, B, C, D and not D, E, F.
Limitation of the type that we look into from 54 itself. That is, has to pertain to regulation and
Of
development.
course, no doubt. Those are the most important words, milord, qualify. So those words bring us back to entry 54, because entry 54 is the legislative entry which authorizes the parliament to make law on that subject. Regulation and development.
To that extent, it is not absolute.
No, it is not. It is. I'm not saying such.
No, I mean, we just.
It's a law
Trying
made
to
by
understand-
parliament in
understand what
exercise
you're
of
trying
its
to say.
powers under power is of 246, but it's subject, which is a general subject. Parliament has been given the power to regulate this by limiting the taxing power of the state. That's the significance of this entry. Now, having said that, that's the scope. First step in the interpretation of entry 50. The next what my friend Mr. Singh was trying to argue. If you look at the entry, milord, it is not a tax on minerals. That could have been so. Very simple thing would have been, milord, Constitution to say taxes on minerals. And then you say what are subject to, etc., etc. But the Constitution makers have not said so. They've chosen a different expression, not minerals. Taxes on mineral rights, obviously, because they were aware that there is a clear distinction between mineral and mineral rights. They're not one and the same. My friend has already given you that exposition. So therefore, while your lordships are interpreting milord entry 50, kindly bear this in mind. This is my humble request. That the entry would have to be.
I have to ask you.
Sorry. It's different.
What is if, without reading the act, how according to you do you say that, well, that is a law which restricts a limitation under entry 50?
Now, milord, if the right is to only the mineral right, if the tax is to the mineral right, then that would only mean that someone who holds the right to extract the mineral, which will be milord by a grant of a lease or some other authority.
But then are you conceding the fact that there is no limitation imposed by Parliament on the right of the states to tax mineral rights?
No, I'm not. They have that under the entry, yes. But now the next question is, has the Parliament put any limitation on that or not?
Right. So
I'm on that.
has Parliament has one aspect is that you are saying it's not a tax on minerals, but a tax on mineral rights.
Exactly.
But according to you, has Parliament left the area of a taxation of mineral rights open to the
No, it
states?
is not. That's what's coming to. Therefore, milord, the law of the Parliament would have to be tested from that angle. Has it left open or has it decided?
According to MMDR has not.
Covers that. It covers that field.
Right.
It provides for levy of milord, for example, the dead rent. Dead rent is nothing but milord, a tax on a right to extract mineral in future time, as and when you think convenient for you. And another important thing you also notice in the schedule to the act, the dead rent, the measure of dead rent is not per ton, etc., as you find for royalty. Dead rent measure is the extent of land, acreage. That's important. If you're not sure, can you have a look at it? 10th schedule. Below, dead rent is provided under section 9A. Corresponding schedule
Don't know mineral.
is below the third schedule. And I would invite your lordship's attention to that schedule because you have not been shown so far that provision. Those vested in the center under the act. But that act, Parliament authorized the central government to get the mines work through government companies on such terms, etc., as they choose fit. So that act was given effect in that manner, where the government companies came in and they. States will not then question further to the government, to the central government, saying that we don't get any royalty from this because you have acquired our property. And it's a huge loss of revenue. The central government will not accepted this, and eventually Parliament amended the law in 1971 and made a provision under that act, introduced new provision, section 18A, enabling payment of royalty even in respect of these lands which are vested in the central government. That act I have to place before you because for case in which I'm appealing that directly relates to that case. That act your lordship will find is at volume 4N L. 4L below. Page 2. Volume 4L, page 2 of that volume, lordship will get that act. I have to place that, I'll come to it immediately.
What is the next point now, Mr.
Yes. The other point which has been already argued, but I owe a duty to the court to explain to your lordships what happened exactly in Kesoram. How did Kesoram come to be referred to a bench of 5 judges? That Kesoram itself extracts. I have to show you that. What is the controversy that the Kesoram was asked to decide? It was not whether the tax on royalty is a tax on mineral rights or on minerals, and whether royalty is a tax or these are none of these issues were conversed at all there. I'll immediately show you that that judgment. I will show you quite a few paragraphs. So the scope in Kesoram was completely different. This was not an issue at all. And much less reconsideration of what happened in the Indian cement. But I have to give it to the ingenuity of my friend Mr. Dwivedi. After the hearing was concluded by the Constitution bench, he came out with his hearing is closed. He came out, stood up to say, I have point that there is some kind of a typographical error in the judgment. This was attempted to in an earlier case, in the Odisha cement case, but given up. This was raised, so we asked the court, are you going to take up this issue now that the hearing is concluded? So Chief Justice Khare, who was presiding the bench, said, certainly not. It was a closed chapter. So nobody addressed any argument to that bench at all on this question. Whether there was an issue or not, let's not go into that. This is a factual thing.
I invite you to go into all that. Actually, we will really go into a unnecessary quagmire, if we muddle, if we start now. No.
This is an historic fact. Unfortunately, we didn't have the transcript facility in those days.
To come another case and then
Right.
whether it was argued, not argued.
Yeah, that's why your lordship find lordship do not find any mention at all in the dissenting judgment of Justice Sinha.
Just that limited significance because that was one of the reasons why the reference was made to us. Now, once a reference is made to 9.
I'll leave it at that, my lord. I only just pointed to how it has happened, but that this is important to know, my lord, that in Kesoram, this was not an issue at
We
all.
were a bench of 7, then certainly whether Kesoram could have done this, whether there was an error in adjustment would have arisen. So we would be bound by adjustment. We were a bench of 7.
May I just take your observation through that Kesoram's decision only?
No, not necessary, Mr. Ganguly. Not necessary.
No, I'm not going to that. I'm only showing you what is the scope there and how it has been dealt with.
That's okay. We'll look at your note. Something on the core now, if there is.
Yeah.
Otherwise, we'll conclude.
Just one paragraph, my lord. Should permit me, volume 5 plus 1.
Not necessary to read Kesoram.
No, I will not. I would not read. I will only give you the the paragraph.
After Mr. Ganguly, Mr. Bagaria will be arguing next. Yeah. Who?
I think sequence Mr. Bagadia, Kambata, myself and Mr. Gu. Subject to 3 o'clock.
Mr. Bagaria, Mr. Datar, Mr. Kambata, and then
Is somebody raising both the palms?
I sorry, I couldn't.
No, I said is somebody raising both the palms because we found many.
Only one. No, then let me take your also to the Polluting Areas Act directly, because that's an additional point. So may I visit your also kindly to see, my lord? Volume 4L.
what do you want to refer to it for, Mr.
My lord, for the Coal Bearing Areas Act, you will also have not seen that. And where there is directly an argument that once the mines come out within the purview of that act, the tax under entry 50 in any case not leviable. So I want to show you also that act, sir, how it is work.
But do we have to deal with that? Let a smaller bench deal with these issues, particularly, I think.
What is the effect of the act?
What is the effect of the act? We shouldn't really.
Imposed by the parliament.
No, this is also,
Mr. Dwivedi, I think that's a better course of action.
this also, my lord,
Otherwise, we start interpreting individual legislations, then we'll miss some legislation. That's not the scope of this legislation.
no, we're not questioning the validity.
Broad
check
aspects
law.
of the legislations can be kept in view.
Volume बोलना है। For it.
Anything else, Mr. Ganguly? Or we
So
can
if you also
Mr.
just
Bagaria
permit me to, my lord, this is an act which is important for the reason that it will throw light as to the scope of, my lord, entry 50. That's why I just want to tell you also what it is all about. We are not asking you also to adjudicate on the nitty-gritty of that provision, no. So volume 4L, if you also will kindly permit me. Page 2. If you also will see the, my lord, the objects and reasons at page 2.
Show us the relevant provision, Mr. Ganguly.
Yeah, my lord, the provisions are, first, if you also will kindly permit me to.
4L.
Yeah, let's go to,
4M.
first see, my lord, the preamble, if you also not go to preamble, my lord, at page 5. Okay.
You're making, and then we can maybe look at everything again.
Section 4 is the preliminary notification which is issued, my lord, by the central government. Once the central government has come to the conclusion that coal is likely to be obtained in an area. So, section 4. Then, my lord, a notification under section 5. It is similar to, my lord, the land acquisition provisions. Effect of notification over happening, my lord, all prospective license mining leases, they all cease to have any effect at all. The whole purpose was to acquire, my lord, the mining rights of those who are holding on to the leases and not operating the mines at all. Then section 6 is a compensation to them, my lord, that's not very relevant. Section 7,
Because, I don't think that's been the scope of the reference. It's not argued this side. If you have, we leave the interpretation of the act, the impact of the act on the, on the appeal or whatever there is before the regular bench. Let's not go into the.
I understand that, Your Lordship. I leave it to the regular bench to go into the question of interpretation if there be any. I was only giving Your Lordship the scheme of it. It's just similar section 10, what happens?
Let's leave it, Mr. Ganguly. I don't think we need to go into the act. Unless there's a formulation which you have and then want to just sort of illustrate that formulation with reference to a particular.
I'm referring to this act for the formulation, Lord, that this is clearly an example of how you can, the central government can control in exercise of its powers under NT 54 and some other powers. This is also NT 42 of list 3, because acquisition is specifically dealt with under 43. But 40, the power of acquisition was exercised, my lord, in furtherance of its obligation under NT 54. That's how I was reading to your Lordship, my lord, the preamble. Preamble says, my lord, this that that we have large deposit of minerals, they remain unexploited, they are required for the betterment of the country and in the larger interest of industrial development in the country. Therefore, my lord, they cannot be left to be unworked for all these years. So we should acquire. That was the whole argument. So this is nothing but augmentation of a law and in terms of
anything else, Mr. Ganguly? Anything else? No?
NT 54. But a few portions, my lord, I have to show to your lordship from the India Cement judgment, just 1 or 2 paragraphs, to indicate how, my lord, India Cement dealt with the issue. So if your lordship will kindly permit me, it is volume 1, page, sorry, my lord, it is volume 5H. No, Lord, I told this. Volume 5. My lord, volume 5.
I was just reading it.
Page, my lord, 1151. First paragraph 24 at page 1166. There the lawsuits are discussing the scope of NT 15 of list 2.
How you will divide that 1 hour between ourselves? We have no difficulty. We'll hear everybody within that 1 hour.
May I just say then that will your lordship segregate that Mahanadi coalfields and refer it to a regular bench? Will your lordship segregate Mahanadi coalfields?
What's segregated is that tomorrow?
That segregation we'll do tomorrow.
Respondent number 87, because
We
that's
can't do it like
covered
this.
by the
We
central
can't do it like this. There'll be a mess if you
Right.
start
Very
just
well.
throwing things like that.
Very well.
What is Maha?
We are looking at this
My lord, on-
conceptually. Tomorrow, all of you give us that these are the matters which have to be detailed. That's why we said that.
Will do. Right.
My lord, on behalf of the NTPC, we'd go by what the learned solicitor has said, my lord.
All right, Mr. Bagaria, then after that followed by Mr. Khambata.
Yes,
Yes.
And yes, Mr. Bagaria, Mr. Datar, Mr.
No,
Khambata.
Lordship will put Compata, he's got some difficulty after.
All right.
Let Compata go first, I'll follow him.
All right. So Mr. Bagaria, Mr. Khambata, and then Mr.
And,
Datar.
and
All within 1 hour.
5 minutes.
We'll try, we'll do it. If your lordship says so, we
You
have.
may be entirely right, but just appeal to the seniors who are preceding you, that's all.
और आप हमसे जुड़े रहने के लिए सब्सक्राइब करें YouTube पर, फॉलो करें Twitter पर और लाइक करें Facebook पर। और ज्यादा जानकारी के लिए आपको टाइप करना होगा सिर्फ न्यूज़ नशा।